Welcome to Ann Babiars and Associates seminar, Protect Yourself and Your Assets, 3 tips for success and 4 mistakes to avoid. The first part of our class today is a rebroadcast of Ann Babiars' radio show, Life After the Box, which airs each Monday at noon Central Time, 1 p.m. Eastern Time, on WLCB 101.5 FM in southeast Wisconsin and northeast Illinois. And the show streams worldwide on lakesradio.org. And don't worry, we've created some visuals to reinforce the important points made in this first part, and we'll join you live for Q&A in a little bit.
This is Ann Babiars, and today I am going to interview my better half, my husband Michael, who retired several years ago from practice as a lawyer. He is a graduate of John Marshall Law School, where he attended on a full academic scholarship. Michael then served as a law clerk to the Honorable Howard C. Ryan on the Illinois Supreme Court before beginning a career as an estate planning, elder law, and asset protection attorney as the owner of his own law firm. He was the chair of the American Bar Association Committee on Elder Law, won awards for service to several nonprofit organizations, and taught as an adjunct professor at Harvard College, and also taught continuing education courses. And in interviewing you today, Michael, I want to pick your brain on asset protection, particularly for these tough times and beyond.
Well, I guess if the listeners are anything like me, they kind of want some comfort and maybe a little less fear in their lives right now.
Absolutely.
And unfortunately, right now, some folks are working through some fears, but it doesn't have to be that way. In my humble opinion, there's really no reason to be stockpiling toilet paper, pulling cash out of the bank, or heading for the hills to hide.
Yes, I know. I've heard lots and seen lots of concerns about those very issues.
Yeah, and I'm not going to tell people here how to be prepper heads or anything like that. This is for people who really kind of like their urban and suburban life, and you just want some direction, perhaps. Again, this is in my opinion. It's not the fault of anybody to be scared, but maybe we should just look at some things that might help.
Well, and that is absolutely true. There are so many people that just don't really understand who to listen to in these times, and it can cause them to panic. So what can you pull out from your old toolkit when you used to do asset protection planning for your clients?
Well, let me look at it this way. I think I can think of 3 things that you could look at that might help. And then if we have time, some cautionary notes too.
Well, okay, so let's jump in.
Well, okay. The first thing I think everybody needs to have in place, again, in my opinion, when we're looking at a situation, whether it's something like this, whether there's something traumatic going on in our society, or really at any time, in order to be properly prepared for something, is to look and be sure that you have in place a medical power of attorney. This can be called medical POA, medical power of attorney, healthcare power of attorney. It goes by a number of different names. And most states have suggested formats for these documents. They're paper documents. They're created, you sign them. They usually have some form of witnessing requirement. I know for our listeners in Illinois and Wisconsin here on the broadcast show that both Illinois and Wisconsin do have suggested forms that their legislatures put into their statutes.
What would you say about that? As far as I know, people can go on different websites and things and get those forms, but what would you say would be the most important thing for them to know at this point?
Well, a couple things. First of all, you always want to check within your existing documents. If you've been to your estate planning attorney, he or she probably recommended and perhaps drafted some of these documents for you already. If you don't have an estate plan, I guess I'll say shame on you.
Well, and isn't that the number one thing in America that people don't have?
Yeah. 70% of all Americans don't do anything. But if you're one of the 30% that did, bravo. And your attorney probably already discussed this with you. But okay, if you're in the 70% that didn't, again, not to fear. The states usually have some suggested form, and yeah, you can usually find these things online. What I would suggest is let's look at it from a couple different points of view. First of all, I would suspect that many attorneys nowadays, in this current time, are acting like many businesses, and that is, if you don't want to come to the office, we can probably do some things over the phone and online. So the first suggestion is if you already have a professional, call her, and you don't have a healthcare power of attorney, can say, hey, can we work this out? Can you consult with me over the phone? We get this thing taken care of, and I can get it put in place, in a reasonable period of time.
But what about witnesses and so forth?
Well, again, most states have some form of witnessing requirement, and typically, as long as it's not someone related to you, you can find a neighbor. Yeah, we're going to have a social distancing issue here, perhaps. But I mean, I guess if you still wanted to stay 6 feet away from each other, they could be, outside on your front porch or on the other side of a room. And as long as you say, hey, I'm signing this right now, and you sign it, and then you walk away and they walk up to it with their own pen, sign it, and leave with their own pen in hand, I think we've met the goal of social distancing.
What about notarization?
The medical one, in some states, it doesn't need a notary.
Okay.
So you'll have to check. If you need a notary, same thing. Sometimes some of them will make house calls. Do you need to get to your local bank or something like that to do it? If you have to, you have to. But oftentimes the medical or the healthcare powers don't need them. So the first step, again, is call your lawyer if you have a relationship with one and say, can we do this where I don't have to come to your office? I want to get this squared away.
What about doing an estate plan on a napkin?
Well, I wouldn't suggest, let's take the one piece we're talking about now, the medical
right.
POA.
I'm sorry, I didn't mean to
okay.
jump ahead on you.
That's okay, no problems. We love your ambition. I used to love clients like you. You need to look at the medical power of attorney form, and most states will say you can do your own document as long as it meets our requirements, and the requirements are things like witnessing, signature, dating, things like that. However, I usually, when I was in practice, my opinion was, and it will be my humble opinion now as I'm just teaching this and no longer giving legal advice, but is to consider sticking close to the statutory form. Because if you need health care assistance and you're going into a hospital, you're going to a medical provider, they're required under federal law to ask if you have one of these documents. They can't force you to have one, but they're required to ask.
Got it. Because I know I've seen on some different social media sites that it's okay to just write it down and that would be your estate plan. And I think that's
it's a little irresponsible.
That's very irresponsible.
Yes.
Exactly.
So when we're looking at this first piece, and we'll talk about another piece here in a little bit, but stick close to the statutory form. See your attorney if you can. If you don't have one and you can find the statutory form for your state online, it's, even a retired attorney always hates to tell people it's a do-it-yourself deal. I don't think it is. But if you're up against it and you have no choice, trying to do one yourself from some online form is certainly better than nothing. And again,
Gotcha.
stick close to the statutory form. Make sure you meet the witnessing requirements, the dating requirements. You've signed it. And the reason you don't want to stray, again, in my opinion, from the statutory form is, again, if it's necessary, if you're admitted somewhere or you're going somewhere for medical treatment and you provide a copy of that, if it's one that's the statutory form in your state, the hospital or the doctor or the staff or whatever are going to say, great, we've seen thousands of these. We know exactly what this is, and we'll scan it and put it in your file. If you come in with something you drafted on a napkin and that's maybe it's witnessed and signed and everything, but they're going to look at it and go, oh, maybe we'll have corporate counsel look at this. And that may delay the ability for whoever you've named under the medical power of attorney to act.
So a napkin, you should probably be using that more for toilet paper these days than for
probably.
your POA.
Probably in today's situation.
Okay,
and
got
again, under the medical power of attorney, guess I should back up for a second and say, you're going to name somebody to act for you. And most often that's going to be maybe your spouse, maybe an adult child, other family member. Doesn't have to be a relative. It's just someone you're comfortable with that that you want to name to act on your behalf, and then you can put as many backups in there as you want. And so when you create that document, you're going to have someone then who can take over making medical decisions for you if, for whatever reason, you can't communicate to a physician.
Got it. Okay.
So, for example, you're in an auto accident and you're unconscious. Or you have a serious illness and you're on so much medication that you really can't communicate well. Or let's say you had a stroke and it affected your speech. The inability to communicate is most often cognitive, but it could also, occur when people have physical issues that can also make them unable to be responsive. And you can cover everything in the medical power of attorney from routine stuff. I want this kind of care. I want this person to consent to treatment, to take care of me. Because as you know, if you've been to a doctor's office in the last few years, medical records are very highly protected. The person under the power of attorney is going to get access to information. Doctors aren't even supposed to tell anybody but the patient what's going on.
That's kind of difficult if someone is unconscious.
Right. So you need that, the power of attorney in place will have an alternate to you to step in there and take care of things. And so you've got everything in there from the routine medical care, consents to surgery, consents to treatment, admission to various healthcare facilities, all the way on up to, there is usually in these documents a section on life-sustaining care. If you're in that situation where it's hopeless and do you want to be maintained on life support? Do you not want it? Do you want it to be discontinued if there's no hope of recovery? You can put in some intent that way as well.
Got it. So many, many things can be covered in this. And one of the things that is probably weighing on people's minds as we're talking is, how do you choose that person to be your agent? And we are up against a station break, but we'll be back shortly. And then when we're on break, we will probably be chatting, and we'll come back with more wonderful information for our listeners. All right. Well, while we're on break here, I want to ask you about some more information that you have about asset protection in general. As you know, on public radio, we can't do calls to action. So we have a couple of minutes here while we're on break. So what is it that you have going on right now?
Well, as you mentioned in my credentials here at the beginning, I teach a lot, and I still do teaching. And I've got a class going now that's offered virtually, meaning that as long as you have high-speed internet connection and a computer, tablet, or smartphone, you can participate in it. It's 8 sessions, 2 sessions a week over 4 weeks, and it's entitled Protect Yourself and Your Assets. So I go through a lot of different topics, including more detail on estate planning, some of the things I'm talking about today with folks, asset protection planning, lawsuits, protecting your accounts, your identity, your reputation, even talking about nursing homes and long-term care issues, about how that can really suck up a lot of money later in life. A lot of information that I used to use not only to help clients, but I've taught before to really lots of students.
Wow. Okay. So would this be intended for a particular age group, or is it all age groups? Kind of what's the gamut here?
Well, I primarily design it for baby boomers. And if we do the math now, I think people are mostly 55 to around 70 that are technically baby boomers. These are folks planning for retirement. Maybe they've just entered retirement. But even if you're younger, or even if you're already retired, there's valuable stuff, valuable info for folks. I usually roll the classes and start them every couple weeks, again, virtually online.
So we're coming out of the station break here in a moment. So if people want to contact you, what's the best way?
Well, I think email is always the easiest. So Michael at AnnBabiarz, AnnBabiarz.com.
Welcome back, everyone. We are talking with my husband, Michael, about some asset protection planning tips that he has for folks as we are perhaps a bit jittery during these interesting times that we're facing.
Well, and really for these times, or really any time.
Okay, so any time. But you know what? I think these times really wake people up to realize that they need to do something.
Yeah, that's absolutely true. Absolutely true. So, well, I was going through some basics here, a couple of thoughts. The first was to make sure you have that medical or that healthcare power of attorney in place, and some ways maybe you could do that where you're still keeping your social distancing and so forth. The second one is there's a companion power of attorney, and it's a financial one.
Interesting. Of course, our health and our finances, very, very big and important issues to everyone.
Right. So the companion to the medical or the healthcare power of attorney is, again, in most states, it's called a financial power of attorney, or sometimes called a property power of attorney. I know Illinois used to use that term, which confused people because they think property means real estate, and they go, I didn't own any real estate. Why do I need one of these? And property is really in the more technical legal sense of the term, meaning essentially anything you own or anything you do financially.
Got it. And I don't want to take you off track, but there is another form out there, and I know we're not talking about that today, but that is also a living will. Not sure. I know that strays a little bit from our topic, but it's also something people might want to be paying attention to, correct or not?
Well, a living will is another medical document. It's sometimes used as a companion to the medical power of attorney. For folks that don't have anyone that could act for them under a medical power of attorney, they could consider a living will. And essentially, it only covers one scenario, and that is you're hopelessly ill and you don't want to stay alive. It doesn't do anything for routine medical care, access to medical records. It doesn't involve anybody else. It's simply a directive to whoever your attending physician is at the time you find yourself in that predicament. So although they were kind of the forerunner to the medical powers of attorney, they were very limited. Again, some folks do them as backup documents. There's no harm in doing one with a medical power of attorney so long as they don't conflict. The only other times people use them as a standalone is typically, again, they got no one.
Got it. Okay.
To be involved.
And that kind of goes along.
I'm sorry, go ahead.
I didn't mean to interrupt. That kind of goes along with the DNR.
DNR is a medical order that your doctor puts in. That's
do
not resuscitate. It may be reinforced by what you've said in your living will or power of attorney, where you say, look, if my heart or my respiration stop by natural causes, don't restart me I don't want to be,
You don't want to
resuscitated.
be, yeah.
So that's, again, for
Got it.
people that are hopelessly ill and they don't want to be being brought back to life when in reality they want to die peacefully and naturally.
Got it. Okay. I just thought those documents might be kind of floating around and people might be wondering exactly
what
how
the
they're
heck
all
is
connected.
it that I have here? Yeah,
exactly.
in my little envelope in my safe deposit box, right?
Right.
And then, so the one final comment on living will is it's the worst named document, I think, in the estate planning world because it gets confused all the time with living trust or with wills. Has nothing to do with your money.
I know it really is. It really is confusing.
Yes, poorly named.
Yes.
But what we are transitioning to here in this segment is talking about the financial power of attorney or the property power, which does deal with your money. So it deals with everything from, yes, you can deal with real estate under a property or financial power of attorney, but you can pay bills, you can sign tax returns, you can execute documents, hire people to assist someone. So the financial power of attorney is, again, a very useful document to have in place if you do become ill, because it can help protect you and your assets from having no plan in place to deal with this situation. Because the alternative is if you don't have a plan in place to cover these two scenarios, if you're not competent to make decisions, you need to have a plan for who makes medical decisions for you. You need to have a plan for who makes financial decisions for you. Many people mistakenly think that, well, I've been married 30 and 40 years. Can't my wife or my husband just do this?
And what happens if they don't have any documents in place and they are married for 30 or 40 years? Can they just do this?
Well, the answer is it depends. Isn't that a very lawyerly-like answer?
It's that gray area, right?
It is. Some states, again, Illinois, I know for sure, does. With respect to medical care, they have usually some form of statute. I think Illinois is called the Healthcare Surrogate Act, where if you have no one named under a power of attorney and doctors say that you meet a certain condition, essentially you can't make decisions, that the statute then looks at a laundry list of people who would make decisions for you, typically starting with spouse or parent, if you're, a young adult, going on down through adult kids and other degrees of relationship, so that it does fill in the blanks, but it doesn't give a person guidance. It does not help if the person that might be top on the list is actually someone you don't want doing
Well, exactly.
that.
Yeah, I was just going to ask you that. What happens if it's somebody that you've been estranged from,
Right.
or situations like that?
You've got a child, maybe you're not married, but you've got a child and you're estranged from your child. Or what if you have 3 kids and 2 of them have one point of view about your medical care and the other one has an opposite one?
Right. Well,
you're going to have disputes. So what happens when you don't plan, or if there's a dispute on the medical side, and if you don't plan on the financial side, is oftentimes you wind up going into court, so that, not you literally, because if you're the one, with the health issue, they're not wheeling you into the courtroom typically, but someone's going to go to court on your behalf to try to become appointed your guardian.
Right.
And a guardian can make medical decisions for you, make financial decisions for you, or make both.
And isn't this, well, I shouldn't say isn't it, but can it be a long drawn out process in the case of guardianship?
Well,
and
yeah,
expensive as well.
It can be expensive because the court costs and the fees and so forth will come out of the estate of the alleged disabled or incompetent person. So you're paying for it typically. You have bonds that have to be put in place. We bond guardians so that they don't steal your money and run away somewhere to a country with no extradition treaty. And then we have to send Dog the Bounty Hunter after them.
Uh-oh. Is he even still in business?
I don't know. That's a good question. And so we have to look at not only the expense, but you asked how long does it last? And the answer is until you die, unless you regain competency. So guardianships can be a really long-term situation. So you have to make sure with these planning, what you're doing is you're trying to avoid the guardianship court. You know, so many people hear about, oh, probate court is horrible. You want to avoid probate court. Probate court being the court where you go, where one goes to settle an estate when someone dies. The issue to me is, first of all, if your estate's in probate court, where are you?
Well, you're not here.
You're gone. You're in a
gone.
different court. You may be being judged by somebody else at that point in time.
Exactly.
But it's not here in this realm.
Exactly. You're on the other side.
Exactly. So the issue with probate court is you're not here, and it's a finite period of time. It's going to end. Your state's going to get settled, and people are going to move on. It may be unpleasant. It may be expensive. But where are you if there's a guardianship going on?
Oh, you're still here.
You're still here, and it can go on again for years and years. So to me, of the two, if you say, I want to only avoid one of these two court systems, which do I pick?
I believe that would be guardianship.
Right. Oh, you're a quick learner.
Hey.
You're a quick learner. So we have a financial power of attorney. And that's my second tip. You got to make sure you have that medical power of attorney or healthcare one. Got to make sure you have that financial one. Now, most states are going to require it to be notarized. So you're going to have a little bit of maybe a social distancing issue if you haven't done it yet. You can still probably communicate with your lawyer over the phone and via digital methods to get this done. You have to be a little careful with these because if you put in the wrong powers, since you're giving someone access to control your assets, the wrong type of language can sometimes create tax issues. So you have to be a little bit more careful about this being a do-it-yourselfer kind of thing.
Well, and how often in practice did you used to fix do-it-yourself?
Yeah, unfortunately, forms? Too often. So let me real quick here go with a couple of other tips. Well, first of all, the third thing I think you can do is if you have a business, you have to consider doing a separate financial or property power for that business because that can raise a whole nother level of sophistication and issues.
Got that. Okay.
So mistakes. You want me to come up with, you mentioned mistakes and things people do wrong with them.
Right.
Okay.
Right.
Let me give you quickly here because I know we're running out of time.
Yeah,
I see
we are.
From the engineer here waving at me.
We're bumping up against it.
Okay. So 4 things. First of all, don't surprise someone being your agent. Ask them, talk to them about it. Make sure they're comfortable doing it. Make sure you have more than one person named in some order of succession. You may say, oh, I want my wife or my husband to be my medical agent and my financial agent. Think longer than that. What if they're not around, they're not able, they can't do this? How do we make sure that we can have other people put these things in place, have successors? So you got to make sure you don't surprise people with doing this, that you ask them, that you make sure you have successors lined up in some order. Don't pick someone that is at conflict with other people in the family and think that, oh, this is okay, everything's going to work out fine. No, you don't need someone to teach others a lesson or anything like that.
Especially at your expense.
Exactly, because that's what will happen. It'll go into probably the court system, and it may be partially at your expense. And then finally, and I think I mentioned this earlier, if you have a business, don't be afraid to separate that out from your personal side because the level of sophistication may be in fact different.
Thank you so much.
Well, and I know we can't do calls to action on public radio, but I hope the listeners do consider making sure they have these powers of attorney in place with the right people on board.
Is it okay if I told listeners how to get a hold of you with any questions?
Sure. I mean, I can't give specific advice because I'm retired, but if they want resources or have similar questions, they can feel free to email me at michael@annbabiars.com.
Excellent.
Well, thank you so much for listening to that excerpt of the radio show Life After the Box. We hope the information within it was really helpful to you. We're going to be back live here in a moment, but I do want to mention that, as was discussed in the interview, I do have a class that I'm teaching. It will be starting, another session of it will be starting soon. It's done virtually, so again, don't have to leave your home to do it so long as you have internet access and computer, tablet, or smartphone. And within 4 weeks, you'll get a lot of good information with 8 sessions, 2 per week. And it's set up such that if you happen to miss a session, there will be replays available, so it's designed to be very convenient, covering a lot of topics, delving a little bit more detail of what we spoke of today, and also lots of other topics as you probably see up here on the screen. And if you have any questions or anything about it, certainly you can email, as mentioned, michael@annbabiars.com. And bear with us here in a moment or two. We'll be back with some live Q&A here as we continue with this seminar on 3 tips for protecting yourself and your assets.